Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar, where we will be presenting a wrap-up of workers' compensation common law decisions from 2021. My name is Hannah Staunton and I'll be your host for today. Before we get started, I'd like to acknowledge and pay respect to Queensland elders past, present and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters and community. If you need to leave a bit earlier, this session will be recorded and we will send a link to the recording out via email by early next week. It will also be uploaded to WorkCover Queensland's YouTube channel. Please feel free to submit any questions during the webinar using the panel on the right-hand side of your screen. If time permits, we will go through the questions with our guest presenter at the end of the session. I'd like to introduce our guest speaker for today's webinar. I'd like to welcome back Scott Falvey of McInnes Wilson Lawyers. Interestingly, Scott actually presented for us for a webinar back in 2019 on the topic of occupational violence. If you'd like to watch this webinar, it's part of our dedicated common law webinar playlist on our YouTube channel. Scott is a principal within McInnes Wilson's insurance team, representing and advising employers, insurers and regulators on workers' compensation entitlements, reviews and appeals. His areas of expertise include insurance litigation across all statutory regimes, with a particular interest in workers' compensation and employer liability claims. Before I pass over the presentation to Scott, I'd like to give our listeners a reminder that any advice given or questions answered today by WorkCover or McInnes Wilson Lawyers is general information only and should not be taken as legal advice. I'll now pass over Scott to begin the presentation. I just want to give it with a preface that Scott and us at WorkCover are in different locations today. So this is our first time presenting from both locations. So we're hoping that we get the technology right. So I'll hand over to Scott now.
Thank you, Hannah. I think I have control of the slides and everything. Does that all look, I think that all looks good at WorkCover's end. If it does, then I'll start with the presentation. Ladies and gentlemen, thank you very much for the opportunity to share with you some of the significant decisions that were delivered by the courts in Queensland in 2021 in relation to employer liability issues. The 5 cases that Hannah and I chose today cover some important issues relating to primary liability, secondary liability in terms of contributory negligence, causation, and some of the approaches and factors that the courts are taking in the assessment of damages at common law. When I explained to my kids what I was looking to share with you today, I sort of explained it in a sense that these were the top 5, the big 5 cases that came out of 2021. And they sort of pressed me about that. I said, it's a bit like, you know, the top 5 people on Facebook that get hits and likes. What they told me was that only old people use Facebook. Nobody uses Facebook anymore. And that if I make any reference to social media, I shouldn't mention Facebook because I'll just embarrass myself. They tell me that TikTok is where it is. So I guess these 5 cases, in terms of those of us that practice in this area, these are the 5 big ones that came down from last year that got the hits. The first decision that I was looking to share with you is a decision of Schokman and CCIG Investments. This is a decision that was delivered by Justice Crowe in the Supreme Court at Rockhampton in May of last year. The facts of the case were a little unusual. The injured worker, the plaintiff, Mr. Schokman, had a history of some pre-existing medical conditions, narcolepsy and cataplexy. Narcolepsy, as you may know, is a condition where people can fall asleep, especially when in relaxed circumstances. Cataplexy is a condition where people can collapse normally as a result of a loss of control of their lower limbs, particularly in circumstances where they may be laughing or they may be engaged in some heightened emotional state. Most clinicians now recognise that there is a clear connection between narcolepsy and cataplexy, and in fact, a number of clinicians define the type of narcolepsy that somebody may be suffering from in the context of whether or not cataplexy is in fact a feature. So that was the background to Mr. Schokman. Mr. Schokman was suffering from these conditions, but had been medicated for these conditions for some time before he took up employment as a food and beverage supervisor on Daydream Island. After he commenced his employment, Mr. Schokman told his employer of the conditions from which he suffered. Mr. Schokman, the injured worker, told his employer that he considered himself to be 100% fit and able to undertake the work for which he was employed. The only concern that he raised was the need for the storage of his medication. The medication was very expensive, and he was concerned that if it wasn't secured in an appropriate place, it could be stolen or perhaps abused. So the employer made arrangements for this medication to be stored. It was stored with the island nurse. The employer provided the particular worker with accommodation on the island. There was a nominal fee of $70 a week in relation to that accommodation. Most of the accommodation was shared accommodation, twin rooms. When the room was first allocated to Mr. Schokman, he was in the room by himself, and this remained the case for about 10 days. 10 days later, after starting with this particular position, another worker, a Mr. Hewitt, was employed and was allocated to share the same accommodation as Mr. Schokman. The way it worked was that they both worked in the catering and beverage area, but in effect, Mr. Schokman, the injured worker, was Mr. Hewitt's supervisor. Now, Mr. Schokman expressed some concern to the employer that he didn't consider it appropriate that a supervisor should be sharing accommodation with someone that he was required to supervise. That concern was noted, but no changes were made to the accommodation arrangement. Mr. Hewitt was described by the injured worker as a bit odd. And part of the reason why he thought that Mr. Hewitt was a bit odd was because in the way that the laundry situation was set up, Mr. Hewitt seems to have taken out the injured worker's clothes from the dryer and folded them for him, and in particular folded his underwear. The injured worker considered that to be unusual and odd. There was evidence before the court that that wasn't so unusual, that in circumstances of a shared laundry, if people needed access to the dryer or whatever, they would often take out what was there, and sometimes just simply out of courtesy and politeness, they would fold the person's clothes that were removed from the relevant machine. So that was sort of contextualized by other witnesses in relation to that, and on the basis that that really wasn't a basis for any sort of unusual or odd behaviour. But the injured worker perceived that as an odd occurrence. Against that background, on 7 November 2016 was a night that the plaintiff finished work and retired to the room. He was preparing for the upcoming week and had ironed his shirts and tended to some other matters, and then he retired to bed. It was after midnight by the time he had finished attending to those matters. During that time, his roommate, Mr. Hewitt, had been drinking. Had been drinking in the island with other staff and in the relevant bars and so on that exist there on the island. In the early hours of the morning, it appears that Mr. Hewitt returned to the room, became disoriented as to where the bathroom was located, and mistakenly began urinating in an area close to the injured worker's bed, and ultimately urinated upon the injured worker. The injured worker woke up. He saw that his roommate, Mr. Hewitt, was urinating upon him. He panicked. The evidence was that he immediately tried to get out of the bed and to leave the room. The roommate appears to have engaged with Mr. Schokman to some extent, was apologising profusely, tried to engage with him, indicating that he was going to clean everything up and that everything would be all right. Seems to have tried to prevent Mr. Schokman from leaving the room as he was trying to. Mr. Schokman ultimately got out of the room, went into the hallway of the accommodation area where it was, and had a cataplectic attack. He collapsed. As a result of that attack, he then experienced severe emotional distress, which ultimately led to a psychiatric condition that became the injury for which he made his claim. The injured worker alleged that the employer should be liable to him for the injuries, the loss and the damage that he suffered as a result of that adverse interaction with his roommate. The injured worker alleged that the employer should be directly liable because it had in place, or it failed to have in place, safe systems of work, particularly as it related to the regulation of workers in regard to the consumption of alcohol. There was no code of conduct or a policy with respect to alcohol use and consumption. The worker also alleged that the employer should assume any liability that attached to the conduct or the act by the roommate, Mr. Hewitt, vicariously. So they should be vicariously liable, assume the liability that would otherwise attach to the roommate, and be liable on that basis. Firstly, the court had to consider, well, what is the duty of care that an employer owes in an employment setting such as this? And if there is a duty that is owed, well, what are the risks of injury that may need to be guarded against by the employer? Justice Crowe found that the employer did owe the injured worker a duty of care with respect to the provision of accommodation in a setting such as this. The issue, though, was, well, what was the content of the duty of care? And the court found that that was to provide reasonable and safe accommodation. Well, what then are the risks of injury that arise from that situation? The court found that the risk of injury that the employer should have identified, assessed, and responded to were the risks associated with adverse interactions between two persons sharing accommodation and the risk that that could result in an injury. Now, you'll appreciate that as a matter of law, it's not necessary to foresee the precise type of injury that someone may suffer for there to be a finding of liability. A general risk of an injury potentially being suffered is sufficient. But of course, it's not enough to simply identify that there's a risk of injury, that there is a duty owed in relation to that risk, and in identifying what the content of that duty is, there has to be a breach of duty. In giving some content to the risk of injury, the court found that the risk associated with an adverse interaction between two workers in a setting such as this was not an insignificant risk, thereby giving rise to the obligation, as we've discussed, the obligation to take remedial action and care in response to that risk. But the court ultimately found that there was no breach of duty in the context of the interaction that was the subject of this claim. The primary evidence that was before the court on the issue of the direct liability of the employer was that the employer should be liable because it failed to have in place rules, regulations, and policies with respect to the consumption of alcohol on the island. The court found this, and if you could forgive my paraphrasing of what is on a found, the court found that the relevant risk of injury was that the injured worker might be involved in a confrontation that was unpleasant. In terms of potentially finding that as to whether or not there was a breach of the duty owed for which the employer should be liable, the court considered that in favour of the plaintiff's case, it was reasonably foreseeable that when two employees of the same gender are required to live in close proximity, like a room on an island, where there are no tight controls in place regarding the consumption of alcohol, there is a not insignificant risk that there could be a confrontation that is unpleasant and could cause problems. But against this conclusion, the court also balanced that there was no evidence that there'd been any problem historically between other roommates on the island living in similar circumstances in the absence of such a policy regulating the consumption of alcohol. The court considered that when looking to give content to whether or not there had been a breach, the problems that arose for the plaintiff was being able to show that the employer, if it took the precautions that the plaintiff contended should have been taken, it would have reasonably reduced the risk of the injury that actually befell the plaintiff. Critically, from an evidential standard, the onus of proof rested on the injured worker. And it was for the injured worker to prove that the employer's breach, the failure to have in place this policy or code of conduct with respect to alcohol, would have reduced or minimised the risk of injury that befell the plaintiff. The court was not satisfied that the employer breached the duty of care because it failed to have in place an appropriate alcohol policy with an appropriate code of conduct in relation to the sharing of accommodation and drinking on the island. This lack of detail of what such policies, if they were in place, and what their content would have been, and what it would have meant in terms of the discharge of the duty of care owed to the employer, were critical problems for the plaintiff's case in respect of causation. So the court found that there was no direct liability that could attach to the employer because of what was contended as a failure to have in place policies relating to the consumption of alcohol on the island, even in circumstances where there were reasonably foreseeable risks associated with persons living in close accommodation or shared accommodation, such as what occurred between Mr. Schokman and Mr. Hewitt. Put another way, and perhaps to illustrate it in a more simple setting, it's not enough to show that after a motor vehicle accident that a defect or a problem or a breach is identified with respect to the car because the horn is found not to. Unless it can be proven that the failure of the horn to work was somehow causative of the injury that had occurred, then the fact that there's a breach or a defect isn't sufficient to ground a cause of action in terms of liability. So the injured worker failed in establishing direct liability against the employer. The court then had to consider to what extent the employer might be required to assume any liability that could be attached to the wrongful act of Mr. Hewitt, the roommate. As to vicarious liability, the court found that there was no doubt that the roommate committed a tort, a wrong, against the injured worker. But again, the court was not satisfied that there was sufficient evidence that notwithstanding the actions of the roommate, that it was appropriate or could be justified to attach a liability to the employer for the wrongful act of that roommate. The court was assisted by a recent decision of the High Court where the issue of vicarious liability was looked at in a little more detail. Now, the decision of the High Court in Prince Alfred College and ADC is an important case that comes from another sector of injury law. It's a case that came out of the jurisprudence around the liability of entities for historical sexual abuse claims. But in that context, in the context of those claims, it was necessary, it has become necessary, for the courts to consider the circumstances that employers should be liable, should be vicariously liable for the actions of employees. And that, of course, is in the setting of institutions and other organisations where employees are alleged to have perpetrated offences or abuse against individuals. Now, even though that case related to a different type of injury altogether, it is still relevant for the analysis that was undertaken regarding the principles of vicarious liability more generally. What I take away from Prince Alfred in terms of its potential relevance to the analysis that was undertaken by Justice Crowe in Schokman's case is that what the High Court tells us in terms of the circumstances that an employer might be found to be liable with respect to the actions of an employee, particularly in the context of a criminal act, and obviously in the case of this roommate, the act or his conduct amounted to an assault upon Mr. Schokman. The liability of an employer for the criminal act of an employee in the setting of employment, the High Court says in Prince Alfred that the sorts of concepts that must be looked at are notions of authority, power, trust, and control. And particularly, this is my word, not the court's, but particularly a notion of unique proximity, that there's some special relationship between the employee who has committed the offence against the other employee that justifies or warrants a finding of vicarious liability. I expect that, for reasons that I'll come to in a moment, that what will be ultimately considered further in relation to Schokman's case is that the court will take from Prince Alfred some of these concepts. Did the employee have a discretion as to the best way to undertake the task in relation to the criminal act that was in relation to the act to which the criminal act was connected? Did the employer have in place checks and supervision with regard to the employee's activities in relation to which the criminal act was connected? Did the employer have in place systems in relation to the regulation of the activities to which the criminal act was connected? And did the employer have in place ways and means of restricting employees from being able to access places or circumstances to which the criminal act occurred? And then, as I say, did the employer allow the employee who committed the criminal act to be in a uniquely proximate relationship with the injured person? Those concepts come from Prince Alfred in the context of a historical abuse setting and the liability that might attach to employees in that area. But I think that these are concepts that we will see further explored in relation to Schokman's case, for reasons that I'll come to in a moment. The court was not satisfied that even if there was a breach of duty in relation to the failure to have in place a code of conduct and alcohol policy, that it caused the injury for the purposes of our legislation in sections 305D and 305E of the Workers' Compensation and Rehabilitation Act, but also in step with notions at common law, that it didn't follow that but for the failure of the employer to have in place a policy with respect to the consumption of alcohol, the plaintiff's injury would not have occurred. Again, there was an evidential problem that the plaintiff faced in this case, in that the court was not satisfied that the plaintiff placed before him, or the injured worker placed before the court, sufficient evidence to show that even if there was such a policy in place, it would have reduced the risk of the injury that had occurred. And ultimately, the court then had to consider whether it was just and reasonable for liability to be attached to the employer in the circumstances of this case. And the court, that is the scope of the duty owed, and the court ultimately found that this wasn't an appropriate case for the employer to be found to be liable directly or vicariously for what occurred. The court found that even though there was an assault, the court did not consider that it was an intentional assault, but rather it was better characterized as a mistake by the roommate, probably precipitated by the consumption of alcohol and him losing his bearings in terms of the whereabouts of the toilet in the room. If the plaintiff had have established liability, Justice Crowe would have awarded him $650,000 in damages. However, because the court ultimately found that liability did not attach to the employer directly or vicariously, the plaintiff was completely unsuccessful and there was no award. This decision has been appealed, as you probably sensed with what I referred to there in terms of some of the principles in Prince Alfred's case. The appeal has been heard. It was heard in about October of 2021, but we're waiting a decision. This will be an important case for Queensland and for employer liability. I suspect, for the reasons I touched on during the summary of that case, that there will be particular focus on how the High Court framed the content of the law with respect to vicarious liability, albeit from another setting. I think the primary legal principles will be taken from Prince Alfred and considered in the setting of Schokman's case. It's set to be an important decision, and it's certainly one to look out for. The next decision I was looking to share with you is one of ACCA's and the Cairns Regional Council. This was a decision that was delivered by Justice Henry in the Supreme Court at Cairns in December of 2021. This was a decision that involved a council worker. Generally speaking, I guess the facts of this case can be summarized to a dysfunctional workplace, in the sense that there were issues with staffing, there were issues with technology, and there were issues with the capacity to attend to the workload that the pay office of the particular employer had to deal with. And the injured worker alleged a psychiatric injury against that background, but in particular, he said that the employer should be liable to him for his injuries because the employer failed to respond reasonably to a complaint that had been made about him and the way that he was running the particular section that he was in charge of within the council. He also alleged that the employer failed to implement a performance improvement plan in a reasonable and an appropriate way, and that the employer failed to respond to inadequate staffing levels. The plaintiff alleged that all of these factors were breaches of the duty of care that the employer owed to the worker, and all caused or contributed to the psychiatric injury that was the subject of his claim. The worker had extensive experience as a payroll supervisor. He'd worked both in similar positions in Australia and overseas. The evidence was that the issues that confronted the payroll unit of this employer had been problematic for some time, and there was evidence that was placed before the court that the plaintiff was there to fix those problems, and that was part of his mandate and part of what was expected of him. The plaintiff alleged that the workload that he had was compounded because of issues with inadequate staffing and issues with respect to problems with technology and systems within that particular unit. In dealing firstly with the complaint that had been made by the union had complained that there were issues with respect to the injured workers' management style that were impacting upon the well-being of some of its members that were involved with or worked in this particular area. And the employer responded to those issues. The court found that in responding to the union's complaint about some of those issues, the employer did not breach any duty, and it was reasonable and appropriate in the way that it did so. So the issue with respect to the response to the union, a complaint by the union, was found not to involve any breach of duty. But the importance of the complaints by the union was that this was a signal or a sign for the employer that this was a dysfunctional area of the employer's business, and it was an area where the plaintiff was struggling and was clearly showing signs of distress that were manifesting in problems managing co-workers, interacting with co-workers, leading to the complaint that had been made by the union. And the court found that while there was no breach of duty with respect to the way that the complaint was responded to, this was the ringing of the bell for the employer to first become aware that there were problems that the plaintiff was suffering in his role at that workplace. The employer argued before the court that when you have an issue such as a complaint by a union and consequently the plaintiff's performance was examined and ultimately led to the implementation of a performance improvement plan, the employer argued that the duty to respond to those sorts of complaints and the ability for an employer to manage an employee with a performance improvement plan or similar named concept is something that there is a contractual entitlement for the employer to manage an employee in that way, and there is a legal duty in terms of responding to issues from a union in terms of dealing with an adverse complaint. So the employer argued that to the extent that there was any duty of care owed to the injured worker as to the outcome of those issues, they were overwhelmed or trumped by broader duties or bigger duties that were owed with respect to responding to a complaint about poor performance by the union or the ability to enter into the management of a worker as a contract of employment might specifically allow. Now, the court specifically rejected that, and the court did not consider that an employer could contend that the implementation of a performance improvement plan, even if the employment contract specifically allowed for that to occur, that was not in and of itself sufficient to displace the duty of care that an employer owed to a worker with respect to how that performance improvement plan was actually implemented and managed. Similarly, even though there was an industrial obligation to respond to complaints by a union in relation to certain workplace matters, that also did not displace the employer's duty of care with respect to how that response was undertaken. And critically, what the court found in relation to the issues with respect to the particularly in relation to the performance improvement plan, is that the employer simply failed to implement it in a fair and reasonable way. And the court was especially critical of the employer failing to follow its own procedures and processes with respect to how these sorts of plans were to be introduced, implemented, and monitored. And I've set out there in the quote some of the particular observations and findings that were made by Justice Henry. And essentially, he considered that against the background of the employer's knowledge that there were significant problems in the function of this particular area, and that the plaintiff was struggling in managing and responding to those functions, that the actual performance plan that was implemented was done so on a flawed and an unfair premise. And to the extent that there was a suggestion that the performance plan was required because of some poor performance on the part of the plaintiff in his capacity as a supervisor, the court rejected that and in effect found that that was actually artificial and did not properly reflect either the factual background or the actual background of what the work circumstances were that the plaintiff complained about. The court went further and actually found that the implementation of the performance plan against that background that I've touched on was in bad faith. Critically, and an important takeaway message for us is that the court found that the employer had failed to take into account what it was aware of in terms of this injured worker's fragile psychiatric state. And especially in circumstances where the court had also found that the premise upon which the performance plan was imposed upon this worker was in circumstances when the employer was aware of that fragile psychiatric state. As to the other allegation that the plaintiff made about inadequate staffing, the court was satisfied that this amounted to a breach of duty as well. Historically, when other issues with respect to staffing had occurred, short-term measures had been undertaken where people had been rotated from other areas to provide support and assistance to this particular area. The court could find no reason why the employer could not have done that in the circumstances over the period that was a subject of this claim, and the employer's failure to do that in the circumstances of this claim again amounted to a breach. And the court was satisfied that the unfair and unreasonable implementation of the performance plan, as well as the inadequate staffing, was sufficient to make a finding that those breaches caused the injury that was the subject of the plaintiff's claim. Damages were assessed at over $1.2 million against the employer. The next decision I was looking to share with you is one of Longbottom and Eleanor Collins. This was a decision delivered by the Chief Justice when she was sitting in the Supreme Court at Cairns in September of last year. This was a physical injury. The injured worker suffered shoulder injuries when he was working on a banana farm. He was a humper and his co-worker was a cutter, and they were involved in the harvesting of bananas. The plaintiff's primary case was that his co-worker, the cutter, had negligently attended to the cut of a particularly tall banana tree in circumstances that did not follow recognised procedure and exposed the plaintiff to a risk of injury. The court was satisfied that the cutter had negligently undertaken the particular cut on this particularly large tree, which gave rise to a risk of injury that befell the plaintiff when it fell upon him. However, having said that, the court found that the plaintiff had placed himself in a position of danger, that notwithstanding the cutter having negligently undertaken the cut in the way that he did, the way that the plaintiff had positioned himself, even if the cut had have been made pursuant to instruction or usual practice, the plaintiff had positioned himself in a position of danger such that when the bunch of bananas fell, he was at risk of injury. And the court dealt with that on the basis that the plaintiff caused or contributed to his injuries through his own negligence. And the court considered that in those circumstances, the plaintiff's conduct by positioning himself where he did caused or contributed to his injuries to the extent of 10%. And so the plaintiff's potential award of damages was reduced to reflect that the plaintiff's contribution. In terms of liability, the decision was relatively straightforward and reflected many well-accepted and established principles with respect to law. But where the case is particularly interesting is how the court then went on to assess this injured worker's damages. And particularly in that area that I wanted to highlight some of the features of how the court went about that just to help sensitize you to the sorts of factors and dynamics that the courts apply when assessing economic loss. This particular plaintiff had a pretty checkered work history. The Chief Justice described it as spasmodic and frequently interrupted by the plaintiff's passion for surfing. In terms of assessing damages, though, the court considered that it was necessary to approach that task on the premise that the plaintiff, by the time he appeared before the court, was in his mid-30s, friends were settling down, and the court found that it was reasonably likely that he would begin to look for more steady and regular labouring work. Even though he may not stay with one employer, regular work was likely to become something that he would become more focused upon. The plaintiff had a history of working as a concrete linesman. That was probably the highest potential earnings that he'd ever had in his employment history. And he also had the history of working in the agricultural sector. And the court considered that in terms of identifying a fair and reasonable notional sum to look to assess how the plaintiff's earning capacity had been impaired because of the shoulder injury that was the subject of the claim, something in the middle of those two extremes of his earning capacity should be taken. The court also, though, had to take into account his residual earning capacity, notwithstanding his injury, and the court considered that that was probably about $250 a week. And interestingly, to get some insight as to how the courts approach these sorts of assessments of economic loss, when the court effectively tries to look into the future to see what dynamics might be relevant to how an injury is going to impair someone's earning capacity, the court found and emphasized that the plaintiff was a gregarious and engaging young person, seemed to be very popular. The court specifically remarked that he'd been asked to be in wedding parties on 3 occasions in the preceding year, all factors that indicated to the court that he was the sort of person that would have reasonable prospects of securing alternate employment. However, having said that, the court also had to take into account some pre-existing factors that were relevant to this particular plaintiff. He had a pre-existing back condition, and there was also the obvious history that his employment was spasmodic and he didn't have a long history of consistent employment. And so that was taken into account as well. And that was also the subject of specific discounting. And the court considered that in terms of assessing future economic loss, all those factors taken together should see a discount of something in the order of 25%. The plaintiff was ultimately awarded $759,000 in damages, but then there needed to be the deduction for contributory negligence, and then there was a deduction for the refund owing to the insurer, and ultimately the award was just over $480,000. The next decision I was going to look at is another decision of Justice Crowe from May of last year in the Supreme Court at Rockhampton. It's Tyndall and Kestrel Coal. This was an injury. This was a case that arose when an underground mine worker suffered upper limb injuries. He drove and operated loaders. The plaintiff's primary allegation against the employer was that he'd never been properly instructed or trained about the risks associated with the vibration that occurs with respect to the operation of loaders, especially underground. The injury that he suffered was described as white finger syndrome, a hand-arm vibration syndrome. The employer admitted that it had breached the duty of care that it owed to the worker with respect to the risks associated with one type of loader that the plaintiff was required to operate, but on another type of loader, the employer denied that it breached that duty. The court ultimately found that the employer breached its duty with respect to the provision of sufficient instruction, direction, warning, and the direction to take remedial action with respect to rest breaks, rotation of duties, and so on for both types of loaders. The court effectively found that the risk with regard to the operation of both types of loaders was essentially the same. court found that the employer failed to warn the worker about some of the key risks of employment, namely working underground with machinery that vibrates significantly. The employer failed to implement a work system that properly responded to those risks, minimising time on the machines and other measures. And the employer had failed to act on a report that it had where specific recommendations had been made with regard to time periods that underground workers should be operating these types of machine. So the employer found that the court found that the employer had breached the duty of care. There was a lot of dispute in the medical evidence about white finger syndrome and the extent that it could be connected to the breach that the court found. Notwithstanding the significant tension between leading experts with respect to this type of injury, the court found that in terms of a legal finding or legal proof, the court was satisfied that on the evidence that was before it, it was satisfactory and appropriate for the court to find that that upper limb condition was connected to the operation of the machines in circumstances that amounted to a breach. Now, while the court's finding may not have met what was considered to be the best scientific position or medical position, in terms of what a court is required to do at law, it was sufficient. There was enough evidence for the court to make the finding that it did. And in terms of this plaintiff's potential award of damages, now again, there were some interesting features that came out here. It was a relatively modest degree of impairment with respect to this upper limb injury, but the damages had to be assessed in the context of an underground mine worker who was 50 years of age with limited alternate employment opportunities. The plaintiff's personality was described as one that was antisocial. He had a history of depression. He didn't like to engage with people. And so the employment opportunities that might otherwise be available to a more gregarious type plaintiff may not have been appropriate or applicable for this type of worker. The court found that notwithstanding any sort of limits on his personality and the type of person that he was, in terms of his work performance, all of the evidence was that he was a very good worker. He was considered to be supportive, a team player, and was generally considered to be very good at what he did. The employer wanted to impress upon the court that this injured worker did have some problems, though, with respect to his performance at work that needed to be taken into account by the court in the assessment of damages, because he'd failed a drug test on one occasion, and there was an issue as to whether or not he'd actually exercised his residual earning capacity to the extent that he could have by not returning to work when it was argued by the employer he had the capacity to do so. Now, the court rejected those arguments, and the court found that taking into account his otherwise very positive work history that was supported by the evidence, those blemishes that the employer identified as being relevant to what is this plaintiff's likelihood would have been of continuing with this or another employer in another area outweighed any of those sorts of concerns and did not require significant weight to be placed upon it. The court ultimately awarded the plaintiff over $1.5 million in relation to his loss. And the final case that I was hoping to look at with you is a decision of Giles and State of Queensland. This was a decision by our Court of Appeal. It came from it was an appeal from a decision of the District Court at Brisbane. That decision was delivered by Judge Reed. Now, the facts of this case was that this was a claim that involved a firefighter. He alleged psychiatric injury. He alleged that the psychiatric injury arose out of his requirement to attend and remain on site at a particularly traumatic scene. And you may remember the tragic house fire at Slacks Creek that occurred in August of 2011. At trial, there were issues with the plaintiff's credibility, and that was a factor that was identified and emphasized by the trial judge. But critically, the in terms of the basis upon which liability was alleged against the employer, the fire service, in relation to the psychiatric injuries that were the subject of this plaintiff's claim. He alleged at trial that the employer failed to check on his well-being when he was at the scene of this particularly traumatic scene. And secondly, that he was required to remain at the scene for an unreasonably long period of time. It was, the evidence was that it was about 9 hours. At the trial, there was a significant contest in the expert evidence about this notion of the periods of time that a frontline worker could or should be exposed to a traumatic situation, and what the employer's response should be to that type of risk so as to discharge any duty of care that was owed. The injured worker relied on evidence from a Professor Harvey. Now, Professor Harvey's opinion was that in order to minimise reasonably foreseeable psychiatric injury to workers, such as frontline workers like firemen in circumstances such as this, there should be a limit on the number of hours that they are actually at the traumatic scene, and that there should be systems in place that allow for the relief of those workers from the scene and the rotation of other workers onto the scene as part of that relief process. Now, at trial, the trial judge just did not accept Professor Harvey's reasoning in relation to that, and in particular was critical of some academic literature that Professor Harvey relied upon to justify that contention. And there was a lot of references to the World Trade Center attacks and some of the literature that came out of that. Professor Whiteford, on the other hand, gave evidence on the part of the employer, recognising that the longer someone is at a traumatic scene, the greater the exposure is, and the greater the risk is that they might respond adversely to such exposure and could lead to a psychiatric injury. But Professor Whiteford said that there was no basis to contend that there should be some defined hourly limit upon persons such as frontline workers as this being at a particular scene. And I guess with one exception, unless a person is visibly showing signs of distress. Of course, that gives rise to other duties. But in the absence of a person such as a fireman showing visible signs of distress, Professor Whiteford's opinion was that any sort of finite fixed hourly period to be in attendance was artificial and was not something that any reasonable employer would build into their relevant work systems. And the trial judge accepted that. Professor Whiteford also gave evidence, which the trial judge accepted, that in the context of an extremely traumatic scene such as what confronted this plaintiff and this employer in relation to this particular setting, there are a number of competing considerations that need to be going on that can't be entirely accounted for by rigid notions such as hourly periods of exposure and secondary relief teams and those sorts of things. And the trial judge accepted that as well. So the trial judge dismissed the claim. As I say, there were some issues with the injured worker's credibility, but ultimately the district court found after a trial that there was no basis to find that the fire service had been negligent because of the circumstances of the plaintiff's exposure or the duration of it in relation to that claim, and further that any sort of follow-up or engagement with the injured worker at the scene, even if that had occurred, that it would have made any causal impact on the psychiatric injury that occurred. So the decision was dismissed. The injured worker appealed. On appeal, the trial judge's findings were confirmed. Again, the Court of Appeal found that the employer did not breach any duty of care owed and accepted the primary findings that had been made by the trial judge in rejecting the evidence that had been offered by Professor Harvey in regards to sort of notional timeframes being imposed on situations such as this. And importantly, the Court of Appeal also found that there was no evidence that even if the employer had have engaged with the worker directly on site during the period of time that he was there, that even if such interaction and engagement occurred, that any psychiatric distress would have been identified or recognised, and that it would have made any difference to the to the ultimate psychiatric condition that the plaintiff developed. If the plaintiff had have established liability, then the trial judge would have awarded the plaintiff $370,000. But because the plaintiff failed to establish liability and breach, the plaintiff was unsuccessful and there was no award. And Hannah, they were the primary cases that I was hoping to walk everyone through.
Thanks, Scott. Thank you, everyone, for tuning in and for being patient with us with a few technical difficulties. Scott, we just want to say a really big thank you for all your efforts that have gone into preparing and presenting today. We do appreciate it. And a big thank you to our audience for tuning in this morning. We hope you found the session informative. As mentioned earlier, this session is recorded and we'll send out a link to the recording to you early next week, and we'll upload a copy onto our YouTube channel so you can refer back to if needed. That's all from us here today at WorkCover. We hope you have a great day. Please keep an eye out on your inbox and on LinkedIn because we'll be soon advertising our webinar for the end of March. So thank you for everyone attending today and have a great day.